There has been a large amount of noise from online conspiracy theorists claiming that the convictions of sub-postmasters for stealing from their branches were a miscarriage of justice. These pound shop detectives didn't attend the trials and all repeat the same dishonest clickbait talking points. The theories seem confined to the fringes of the internet and marginal publications such as Private Eye, Computer Weekly, the BBC, the Times and the Guardian. After hearing all the evidence, several juries and judges disagree with them. Senior lawyers are not raising any doubts about the convictions. Okay, some senior lawyers are now raising doubts, but they're not experienced prosecutors. Some conspiracy theorists even assert that the civil actions brought by the post office were wrongfully pursued. The conspiracy theorists are unmoved by the fact that many of the sub-postmasters admitted their guilt in court. If these truthers had attended the court hearings, or watched someone reading the transcripts on YouTube for 10 hours, they would know that many accused accepted as fact that they falsified their accounts with the necessary dishonest intent. In choosing to do this, to admit this, they would have had access to qualified legal advice and made the decision to plead guilty to take advantage of lesser sentences. There is no other explanation. Thank you, Christopher. Some falsehood peddlers have theorised that computer bugs might have caused shortfalls of money. But the cases weren't brought on the basis of computer bugs and had nothing to do with them. The cases all heard expert evidence confirming that the money was missing, and a raft of other circumstantial evidence. All these nutters are now saying they've got new expert evidence, but I've looked at it and it is bollocks. One of their new experts is a global warming denier. The Court of Appeal will not listen to it. Insofar as computer evidence was used, it was merely presented to prove that the branches had suffered missing money, a necessary ingredient of the offences or civil actions. The noise generators say that all the post office did was turn up in court with a printout and get a judgment. But there were multi-day trials or hearings in which these defences were given a fair opportunity and rejected. The sub-postmasters who were accused were always the common factor present in all the offences, for those offences they were accused of. The conspiracies rely on people not examining how the money went missing. I would suggest that the fact deniers actually try reading the judgments. In the Marine Drive case, the sub-postmaster tried the computer bug defence. This was entirely refuted. The expert witness concluded there was no evidence whatsoever of any problem with the system. She was unable to identify any basis upon which the Horizon system could have caused losses. The defendant did not call his own expert, having obviously decided it would not help him. In the criminal trials, there was circumstantial evidence that it was these sub-postmasters that had a disproportionate problem with losing money compared to most others. It was very rare for most others to lose money. Stable post offices do not suddenly lose money. The juries and judges were therefore entitled to find that this meant the sub-postmasters were taking it. It does not make it a computer bug case. There was other circumstantial evidence, such as in the Marine Drive civil case, the safe was found unlocked with the keys in the door, and the travellers' checks were not secured in the safe. The sub-postmaster did not offer any explanation of this, which can only mean he was advised that doing so wouldn't help his case. In the West Byfleet branch case, The sub-postmaster also used the computer bug defence, but she didn't do this at first. The post office expert investigators reliably concluded quickly that Shortfall did not steal the money. At first, the sub-postmaster admitted that someone was stealing money from the office, but she claimed it wasn't her. She only brought up the computer bug just before the trial, and the jury were told they could draw an adverse inference against her from this. This is completely normal, and the jury plainly did draw such an adverse inference, as they were entitled to do. The use of the sub-postmaster's shift patterns showed that she was the only person present at the particular set of incidents she was charged with. The jury were therefore entitled to find it was unlikely there were two thieves at work. Yes, that's right, Susan. Looking back at the actions of the sub-postmasters in hindsight, and with the advantage of hours of time to prepare and analyse the minutiae of every little detail in this case, the prosecutor tore apart her defence entirely by showing no one would ever act that way if innocent. Many sub-postmasters signed off their incorrect accounts, which can only be an attempt to gaslight and throw their employers off the trail. Isn't that right, Caroline? Yeah, that's right, Liz. And the West Byfleet sub-postmaster was accused of telling lies on her CV under cross-examination. The computer bugs were dealt with at the trial. It's worth reading the prosecutor's summary in its entirety here to make sure you actually understand the case that was presented and aren't some kind of thicko. Defenders of pension thieving generally don't want to do this. Here are some key extracts from the prosecution summary. So Professor McLaughlin's anxiety about system failure in fact appears to be based on an irrelevant red herring. So what evidence is there of a computer problem? There is none, and you judge the case on the evidence. So it all depends on her. He makes findings, but you have to judge his findings, and Mr. Jenkins' findings, by the evidence of the sub-postmistress. And Calendar Square is a good example of this, because the sub-postmistress's evidence shows that it is irrelevant. Yes, that's right, Caroline. He then goes on to say, so there is no evidence of computer error at all. If Mr. Hadrill can find some for you, it will be very interesting and important to hear what he has to say. But there is none. Thanks, Liz. So, there it is in plain words, from the prosecutor heard in court. The court also heard that while the West Byfleet trial was taking place, the prosecutor had been bringing actions in respect of 17 other post offices. People who disagree clearly cannot have read this. There was ample circumstantial evidence on which to convict, as the judges and juries all agreed. A respected lawyer working for the post office said all this in court, and it was confirmed by the experts. So it's hardly going to be wrong, is it? No, that's right, Caroline. Unlike what a lawyer for the thief would say just to get his client off. The suspicious circumstances of the missing money were discussed in meticulous detail during both trials, and if computer experts can't be bothered to engage with the totality of the evidence, then they should just shut the fuck up. We were paid £23,000 by the police, by the way.